Lecture 3. Police measures and measures to ensure proceedings in cases of administrative offences. Police and the protection of human rights. First of all, I have to introduce myself. I'm a lecturer at the Department of Administrative Law, Process and Administrative Activity of the Faculty of Training of Specialists for Preventive Activities of the Dnipro State University of Internal Affairs, Senior Lieutenant of Police Kristina Деревянко. Telling about police measures, first of all we should talk and consider the delivery of the infringer. Bringing the offender is used by a police officer to draw up a report on administrative offense if it is impossible to draw it up at the place of the offense, if drawing up a report is mandatory. It can be concluded that in the case of consideration of a case without drawing up a protocol, the person is not brought in. The offender may be taken to the police, headquarters of public formation for the protection of public order and the state border, a public point for the protection of public order. The offender must be brought in as soon as possible. The stay of the delivered person in the headquarters of the public formation for the protection of public order and the state border or a public point for the protection of public order, the premises or executive body of the village or settlement. Council may not last more than 1 hour, unless otherwise provided. No protocol is drawn up on the delivery of the person, but report on the delivery of the person is drawn up. Information on persons who have committed administrative offences and who have been brought to the administrative building of the police unit shall be recorded in the register of persons brought, visitors and invitees. Information on persons who have committed administrative offences and who have been taken to public order protection units or precincts shall be recorded in the register of persons taken to public order protection units or precincts. In addition to the delivery of a person, the CUAO provides for the possibility of applying measures to ensure the proceedings. In cases expressly provided by the laws of Ukraine in order to termination of administrative offences when other measures of influence have been exhausted. Identification of a person. Drawing up a report on administrative offence if it is impossible to draw it up at the place of the offence, if drawing up a report is mandatory. Ensuring timely and correct consideration of cases and enforcement of decisions on administrative offence are allowed. Administrative detention of a person. Personal inspection, inspection of things, seizure of belongings and documents, including a driver's license, temporary detention of the vehicle, suspension of drivers from driving vehicles, examination for the state of alcohol, drugs and other intoxication, as well as for being under the influence of drugs that reduce their attention and reaction time. Types of interim measures in proceedings. As a measure to ensure proceedings in case of administrative offence, administrative detention is a compulsory short-term restriction of the offender's freedom of action and movement. Administrative detention of a person who has committed an administrative offence may be carried not only by officials authorized by the laws of Ukraine. Administrative detention may be applied not for all administrative offences, but only for some of them listed in Article 262 of the Code of Administrative Offences. As a rule, administrative detention may not exceed 3 hours. It is a general rule. Such a period of detention is called a general detention. Administrative detention is called out by the internal affairs bodies when committed. Petty hooliganism, domestic violence, violation of the procedure for organizing and holding meetings, rallies, street marches and demonstrations, spreading false rumors, malicious disobedience to a lawful order and demands of a police officer, member of a public formation for the protection of public order and the state border, or a military officer, or insulting them. Public calls for non-compliance with the demands of the police officer. In case of contempt of court, unlawful access to information in automated system, violation of the rules on currency transactions, rules for the circulation of drugs or psychotropic substances, illegal sale of goods or other items, petty speculation, hand-to-hand trading in unspecified locations. When drinking alcohol in public places or appearing in public places in a drunken state that offends human dignity and public morality. In case where there are grounds to believe that a person is engaged in prostitution. In case of violation of traffic rules, rules of hunting, fishing and protection of fish stocks and other violations of legislation on the protection and use of wildlife. In case of violation of the rules of state of foreigners and stateless persons in Ukraine and transit through the territory of Ukraine. Thus, we're talking about 18 cases of administrative detention. A report on administrative detention is drawn up which indicates the date and place of its execution, position, surname, name and patronymic of the person who drew up the protocol, information about the identity of the detainee, time and motives for detention. The protocol is signed by the official who drew it up and the detainee. If the detainee refused to sign the reports, an entry is made in it. The location of a person detained for committing an administrative offense shall be immediately reported to his or her relatives and request also to the owner of the relevant enterprise, institutions, organization or authorized body. Administrative detention of a person who has committed an administrative offense may last no more than 3 hours. Persons who have illegally crossed or attempted to illegally cross the state border of Ukraine violated the procedure for entering and leaving the temporarily occupied territory of Ukraine or committed other actions to violate the established entry and exit regime may be detained up to 3 hours for drawing up a protocol and, if it necessary, for identification and clarification of the circumstances of the offense, up to 3 days, with notification in writing to the prosecutor within 24 hours of the moment of detention. Persons who have violated the rules for the circulation of drugs and psychotropic substances may be detained up to 3 hours for drawing up a protocol and, where necessary, for identification, medical examination, clarification of the circumstances of the acquisition of seized drugs and psychotropic substances and their examination, up to 3 days, with a written notification to the prosecutor within 24 hours of the moment of detention. A report on administrative detention is drawn up on a special form printed in accordance with the technical description, on which the relevant series and numbers are affixed. All details of the administrative detention report must be filled in the legible handwriting. It is not permitted to cross out or correct the information entered in the administrative detention report, as well as to make additional entries after the administrative detention report has been signed by the person in respect of whom it was drawn. The report on administrative detention shall indicate the date and place of its preparation, day, month, year, name of the settlement, position, surname, name and patronymic of the person who drew up the protocol, special rank, surname, name and patronymic. Information on the identity of the detainee, surname, name and patronymic without abbreviation, day, month, year of birth, actual place of residence. Time and reasons for detention, the name of the police body to which the person who committed the administrative offense was taken, its location, day, month, year and time of delivery, part of the article and article of the CUAO that provide for administrative liability for the administrative offense committed, as well as the reason for detention, termination of administrative offense, other measures of influence, drawing up a report on administrative offense, and, if it is possible, to draw it up at the place of commission of the offense. When drawing up a report on administrative detention, the official carrying out the administrative detention shall explain to the person who committed the administrative offense his rights. Under Articles 55, 56, 59, 63 of the Constitution of Ukraine and Article 268 of the Code of Administrative Offense. In accordance with the law of Ukraine on free legal aid and paragraphs 2 and 10 of the Procedure for Informing Secondary Legal Aid Centers of Ages of Detention, approved by resolution of the Cabinet of Ministers of Ukraine number 1363 of 28 December 2011. When drawing up a report of administrative detention, a person who committed is explained her rights to receive free secondary legal aid. The protocol on administrative detention is signed up by the official who drew it up and the detainee. If the detainee refuses to sign the report, a note is made in it. Pursuant to Part 2 of Article 261 of the Code of Administrative Offences, the location of a person detained for administrative offense shall be immediately reported to his or her relatives and his or her request, also to the owner of the relevant enterprise, institution, organization, or authorized body. A corresponding entry is made in administrative detention report, indicating the day, month, year, and time who was notified and how. If it is impossible to inform relatives and if the detainee refuses to provide information to notify them, a correspondent record is made by the detainee and the official who drew up the administrative detention report, indicating valid reasons. Parents or person-in-law co-parents must be notified in the detention of a minor. The report on administrative detention indicates the time, date of notification, who was notified and how. Before being placed in a room for detainees and taken to the police station, if the office where the person who committed the administrative offense was taken, in accordance with Article 264 of the CUAO, the authorized official of the same sex as the person being examined and in the presence of two witnesses in the same sex conduct a personal and property search. Inspection is a procedural measure applied to a person who has committed an administrative offense, and cursory inspection is a preventive measure applied to a person who has not yet committed an administrative offense. The inspection of belongings, hand luggage, and other items is carried out in the presence of the person who owns them. A search of belongings may be carried out by authorized police officer when a detainee commits an administrative offense. A protocol is drawn up on the personal search and inspection of belongings, or a corresponding entry is made in the protocol on the administrative offense or in the protocol of administrative detention, indicated this. Surnames, names, and patronymic places of residence of the two witnesses. A list of things to be inspected and items of clothing that are on the person at the time of his or her detention. Information on the presence or absence of bodily injuries on the detained person. If bodily injuries, bruises, scratches, cuts, wounds are found, it should be noted on which parts of the body they are located. If a detainee needs medical assistance, the protocol should indicate the time of its provision, the number of the ambulance crew, the name and initials of the doctor to whom the detainee was sent. If a detainee submits complaints or comments during a personal search and inspection of belongings, a corresponding entry is made in administrative detention report indicating their substance. A personal search and inspections of belonging are indicated in the administrative detention report shall be certified by the signatures of the authorized person who conducted the search, the detained person, and witnesses. Consider the issue of testing for alcohol, drugs, and other intoxication. Drivers of vehicles in respect of whom the authorized person has reason to believe that they are in state of alcoholic, narcotic, and other intoxication or under the influence of drugs that reduced attention and reaction time, hereinafter referred to as the state of intoxication, in accordance with the signs of such a state established by the Ministry of Health and the Ministry of Internal Affairs, are subject to inspection. The inspection is underway by an authorized person of the patrol service and the place of stopping the vehicle using special technical means, a doctor at a health care facility. Temporary detention of a vehicle by an authorized person of the National Police is carried out in cases provided for in Article 265 and 2 of the Code of Administrative Offences. In particular, when it is possible to eliminate the cause of detention at the place of detention of the administrative offense, and provides the forced termination of the use of such a vehicle by blocking it with technical devices or delivering it to a special site or parking lot of vehicle created significant obstacles to traffic. Temporary detention of a vehicle is also carried out in the event that a debtor vehicle is found to be wanted list in accordance with Article 40 of the Law of Ukraine on Enforcement Proceedings. A police officer is prohibited from participating in blocking or evacuation of vehicles in cases not provided by law. The vehicle is delivered to a special site of parking lot using special vehicles, tow trucks. To deliver the vehicle to a special site or parking lot, the police officer calls a tow truck through the duty officer of the relevant territorial body of the National Police of Ukraine. Upon arrival of the tow truck, the police officer, in the presence of the two witnesses, a representative of the enterprise, institution or organization that owns the tow truck, draws up an act of inspection and temporary detection of the vehicle. The vehicle may be temporarily detained for the period necessary to resolve the case of an administrative offense, but not more than 3 days from the date of such detention. Withdrawal of the driver's license and deprivation of the right to drive vehicles. Police officers temporarily withdraw a driver's license if there are grounds to believe that the driver has committed an offense under the Code of Administrative Offences, which may result in an administrative penalty of the form of deprivation of the right to drive. A record of the temporary withdrawal of a driver's license is made in Report on Administrative Offences, Article 265 and 1 of the Code of Administrative Offences. Until the court issued a ruling on an administrative offense and the ruling enters into force, the police officer issues the driver a temporary permit, Annex A to the instruction, to drive a vehicle for a period of up to 3 months from the date of withdrawal of the license. The front of the temporary license to drive a vehicle shall cross out the categories of vehicles that the driver is not entitled to drive and make the following entries: the date of temporary withdrawal of the driver license, position, surname of the police officer, number of his badge, the date of the offense, series and number of the protocol on administrative offense, the article of the Code of Administrative Offense under which the report of administrative offense was drawn up, the sanction of which provides the imposition of an administrative penalty in the form of deprivation of the right to drive a vehicle. In the event of the administrative offense for which an administrative penalty of the form of deprivation of the right to drive vehicles is imposed, a person whose driver's license has been temporarily withdrawn for a previous administrative offense shall not renew the temporary permit for the right to drive a vehicle issued in the first case. In the relevant columns of the temporary driving permit, the police officer shall make a note of the offense. The stop of a temporary permit to drive a vehicle is filled in by the police officer who issued and subsequently kept in the relevant unit to ensure proper control over the legality of its issuance to road users. The driver's license is withdrawn until the decision on the administrative offense comes into force. Peculiarities of temporary seizure of an animal. If there are grounds to believe that the owner of the animal had committed a violation for which an administrative penalty in the form of confiscation of the animal may be imposed in accordance with the code, a person authorized to draw up a report on administrative offense in accordance with Article 88 and 1, 89 and 154 of this code shall temporarily seize the animal until the decision on the case of an administrative offense enters into force. A protocol shall be drawn on the temporary seizure of an animal, or an entry shall be made in the protocol on administrative offense. The procedure for temporary seizure of an animal is determined by the Cabinet of Ministers of Ukraine.